Chairman, and thank you, Director, for being here. Just a comment, something like a quarter of the patents in the United States come from the Silicon Valley, and I know that there has been a strong interest in the Valley for our next office, and I'm hoping that you will consider that overwhelming fact as you consider these various offices. I just a small comment on the patent thicket and the kind of the patent wars that are developing. I understand your point that you made to Mr. Watt, but it's certainly not just the cell phone wars. It's also the social network wars. And recently, a independent analysis suggested that in the infringement litigation currently underway, for example, between Yahoo and Facebook, that there were over 30,000 patents implicated in that litigation. And it seems to me, if you're a software engineer and there's potentially 30,000 patents implicated, I mean, there's no point in even looking in terms of infringement. I think there's a problem, and I think we're not going to solve it here today, but I think it bears examination, and especially for the engineers involved in the Valley. And I'm hoping to have some discussion among the parties, because that kind of litigation, everybody has to do it both as a sword and a shield, but from a 30,000-foot level, it's draining a lot of money from innovation that I think is a problem. I want to talk about the inter-parties situation. Some have suggested that the PTO will be accepting too many re-exams, even though the AIA raised the acceptance threshold, and some have suggested that you should have voluminous initial disclosures, which I have some questions about, and I'm wondering what your thoughts would be, whether what the office would do and what would the cost be for the office if the patent claims scope were similar to a Markman hearing as opposed to what I think most of us envisioned when the bill was crafted. I just don't know how we would pay for that, but maybe that's a concern on my part. I'm also interested in the costs for a company defending itself against an invalid patent in district court. How would that compare if we were to go to a more voluminous filing, as some have suggested? And your comments on that would be very welcome, as well as any other in that as the process has developed.
Well, thanks for the questions or comments, Congresswoman Lofgren. And I will tell you, I am concerned about patent wars also, despite my previous comments, while I think they're a reflection of marketplace realities, and they involve creative companies on both sides.
Yes.
You mentioned the Yahoo Facebook suit as another.
And I'm not taking one side over the other. I'm just noting that for business reasons, companies are buying up and using as a sword and a shield these gigantic portfolios that are weighing down sites.
But I think the AIA provides us with an opportunity to help sort those things out much more cost effectively. The second part of your question, in a suit that involves however many patents between litigants, if we can reassess the patentability of those inventions quickly and cost effectively through post-grant opposition inter-parties review at the PTO, that's where the action is, and that's where parties can then quickly and effectively assess their relative positions and resolve those suits without having to spend extreme amounts of money. So that's the first part of the question. Now, I'll be out in your home state, my home state, California, later this week, no, actually first of next week, talking about these various issues with judges and with members of the IP community there, specifically to learn more about this and make sure that we're doing everything we can at the PTO as we implement the AIA. So relative to the second part of your question and voluminous disclosures in these post-grant processes, I'm concerned also. One thing I will tell you is that if I do not believe the USPTO will be living up to the mandate of the AIA if we implement it just like a district court process. That is not what you intended. I do not believe that's what Congress intended. I do not believe it's what's reflected in either the statute or the legislative history, and I do not believe we can succeed that way. Parties who want to spend millions of dollars on voluminous, extensive document discovery with lawyers fighting with each other inexorably and then dumping millions of documents on dispute resolvers need to go to the district courts to do that. That's what district court discovery looks like. You put in a process for us that you want us to get done in a year. That's going to require a lot more oversight and a lot more proactive involvement and a lot less voluminous disclosures by parties. There was one of those smartphone war suits. There was a report just last week of one of the parties that filed a document that was over 1,000 pages. And the judge looked at the document and reactively said, I am not going to even read this thing. The situation's out of control. What we're trying to create in the PTO is a system that proactively prevents those kinds of abuses and waste from happening by having our ALJs reasonably involved all along the way, just like the district courts are starting to do with magistrates who are getting more involved in litigation all the way along the way. It's a best practice being recognized in the district courts. We want to do the same thing with our procedures so that our folks are involved, helping to guide the parties in a streamlined, cost-effective, fast way, and not get into this situation with voluminous, uncontrolled disclosures that will run up costs, just like in district courts, waste millions of dollars, not behave in a manner that's consistent with your statute, and create a process that we will never be able to administer at the PTO. So I'm very alert to your concern. We're trying to balance all of these issues with parties on the one hand who want wide open district court-like processes in the USPTO, and on the other hand, get these processes completed in a reasonable amount of time.
If I could, Mr. Chairman, I'm wondering if you could tell us what percentage of accepted inter-parties exams today result in a change to the claims.
Well, I'm doing this from memory, but today my recollection is that a high percentage of cases that are accepted actually do result in a change to the claims. And a number like 85% is sticking in my mind, but it may be slightly more or less, but it is a high number. I believe that actually is a testament to the strength of the process, that when we accept one of these, we're into review, it's one that we really do need to look at.
I yield back, Mr. Chairman. Thank you very much.
Thank you, Ms.